Case of People versus Latrell King. The record should reflect the jury is not present at this time. And when we broke yesterday afternoon, I had counsel given proposed jury instructions, asked you to review them over the evening. Any additions, deletions, objections, or corrections, Mr. Souter?
Judge, I spoke with Ms. Lewis earlier, and the only deletion I would request would be the jury instruction relating stipulation. I don't believe we stipulated to anything during the course of the trial. It might have already been removed.
Which one are you referring to?
3 point.
Okay. Anything else, Mr. Souter?
No, Your Honor. Thank you.
Mr. Crawford?
The instructions are fine, Your Honor.
All right. Then are we prepared to proceed with closing arguments, Mr. Souter?
Yes, after the defense rests on the record.
Mr. Crawford?
Yes, that's correct, Your Honor.
All right, we'll bring the jury in. You can rest, or you can go right into closings, all right?
Yes, Your Honor.
Morning, ladies and gentlemen. And Mr. Souter, having rested yesterday, Mr. Crawford, you may proceed.
Your Honor, at this time, the defense rests.
All right. Having said that, we'll go right into closing arguments. Mr. Souter, you may proceed.
Good morning, ladies and gentlemen of the jury. Again, thank you for being here this morning, and thank you for being attentive and listening to this case as it's been presented over the last couple of days. Can anyone hear and see me okay? Okay, thank you. Again, as we've kind of talked throughout the course of this case, this is my closing argument. As I stated in my voir dire, because the burden's on myself to prove this case, I get to close first. Mr. Crawford gets to close, and I get the final rebuttal closing after Mr. Crawford as well. Again, ladies and gentlemen, you've now heard the evidence of this case. The purpose of the closing is for me to summarize what I believe the evidence to show you, the jurors. I know that after I get done giving my belief of the case, Mr. Crawford will come up and give his belief of the case as well. I want to caution each and every one of you that realistically, sitting as a juror, it really is just using your common sense. I can understand being a part of a trial. It might be a new experience. It might be a confusing experience when you hear objections or not really sure what is happening 100% of the time. But I tell you, if you apply your real world experience in a common sense way, you'll get to the bottom of this case. Now, using your common sense, ladies and gentlemen, Mr. Crawford stated in his opening that this is a case of motivation, deception, and manipulation by the victim. Now, again, ladies and gentlemen, using your common sense from the evidence that was produced from that stand, who had the motivation in this case? Who used deception in this case? And who manipulated someone in this case? And the answer is the defendant. Latrell King Jr. did all three of those things, and it describes his actions to a T, not the victims. Ladies and gentlemen, this case started back on October 18th of 2020. As you heard, and as Ms. Van Wormer testified for great length of time, she was not hiding anything. She had contacted the defendant. They had made plans for Sweetest Day the night before to go down to Detroit, to go have dinner, and to enjoy themselves. It's true at that point in time, on October 18th, there was no contact orders in place for the defendant and the victim. Now, I think you could understand from Ms. Van Wormer's perspective, not every interaction with the defendant was bad. Not every time they hung out did he assault her, or abuse her, or control her, or be possessive of her. And as you heard Ms. Van Wormer state, she loved him at a point in time, and she wanted to make him or help him become a better person. So on the 17th, going into the 18th of October of last year, they go down to Detroit. They have dinner. They do consume alcohol at dinner, something Ms. Van Wormer did not shy away from. We've stated from the beginning that on this same night that the defendant was arrested for breaking and entering into her residence, Ms. Van Wormer was arrested under the suspicion of drunk driving. While at dinner, they do consume alcohol. She didn't hide that. She asked what she consumed and what they had, and she said Latrell bought a bottle of Hennessy. But a question that was never asked or answered was, how much of that Hennessy did you have, Ms. Van Wormer? All it was stated was that by the end of the night, that bottle was consumed by the both of them. Going into the early morning hours of October 18th, Ms. Van Wormer, inappropriately so, drives the both of them back from Detroit, potentially under the influence of alcohol. On the way back, in the car ride and close to Saginaw, or within Saginaw County, the defendant tells Ms. Van Wormer he consumed a Xanax. Not only does he tell her he consumed a Xanax, he pulls a bag of them out of his pocket and shows her. This is when the contact becomes non-consensual, because Ms. Van Wormer knew, based on his patterns of abuse while under the influence of alcohol and Xanax, that he was probably going to abuse her again that night. And she knew to herself, I have to separate myself from this situation. Who cares if they were going back to her place with the original plan? Who cares if they were going back to his place with the original plan, or hanging out in general after that? She decided to stop that contact at that point. So what'd she do? She went to the Marathon gas station on Court Street, a block from his house. She asked him to go pay for gas so he could remove himself from the car and so she could drive away. As soon as he was out inside the gas station, you heard her. She floored it. She got out of there quickly. And by the time she was within a block or two of her home, she was traffic stopped by the police for speeding. Again, you heard her state, and the facts and evidence show that she was trying to get home quickly. She was trying to get home to safety. She was unsuccessful. And she was traffic stopped as a result. She didn't deny this. She didn't deny the fact that she shouldn't have been driving. She didn't deny the fact that she consumed alcohol. She didn't know that the defendant's keys and phone were still in her car when she left the gas station, as she told you, ladies and gentlemen. But instead of walking to his house on South Granger Street, a block away from the gas station, the defendant proceeds to go to her residence at 4493 Mackinac Road here in Saginaw Township. As you heard Ms. Van Wormer state, that was about a 25-minute walk. A conscious decision by the defendant. In Mr. Crawford's opening, he stated the defendant didn't have a phone to call a taxi or an Uber to get home. It was a 3-minute walk, ladies and gentlemen, to get to his mother's address that he shared with her on South Granger Street. 3-minute walk. Yet he decided to walk 25 minutes to Alexa's house on that night or early morning hours. He did so because he was mad. He was mad he was left at that gas station. How could Alexa do this to me? Probably went through his mind. And that's why you can base intent on someone's actions alone without words. Why did he walk that 25 minutes to her residence when his house was right across just a couple blocks over? Eventually, when he gets to her home, he does not know she wasn't there. He did not know she had been arrested earlier in the night. Nonetheless, he wanted his keys and he wanted his phone, as Mr. Crawford has stated. So what does he do? He shatters the back window to the residence. Now, I can't prove he used those cement blocks, but you can infer from the evidence and photographs that that cement block right underneath the window probably was used to shatter it. It was a thick window. It was a modern window that was double paned. It's not easy to break those, ladies and gentlemen. Yet that didn't stop the defendant. At some point in time, after he broke the window, still probably not knowing if Alexa was home, he decided to enter the residence. In doing so, he injured himself completely. He had cuts on his face, his arms, his hands. He had blood all over his body when the police arrived. He tracked blood in from the window onto the sink, onto the floor of the kitchen, then into the living room where the couch was, the carpet, the stand with the light on right next to it. He tracked blood then more throughout the home into the bathroom of the residence, as we discussed. I am not saying the defendant ever assaulted Miss Van Warmer on the 17th or 18th of October of last year. Never made that claim. Miss Van Warmer testified the defendant never assaulted her or attempted to hit her on that date. But again, why would the defendant go to such great lengths to get into that residence on that date? The answer is, ladies and gentlemen, is because he went to that house with the intent to do something. He went with the intent to commit ag stalking or aggravated stalking, or he went there to go assault the victim. Now, Mr. Crawford stated in his opening, this is a character assassination of the defendant by all these prior bad acts you get to hear about between himself and the victim. July 14th and 15th of 2020, August 10th of 2020, August 30th of 2020, leading into the 18th of October. The reason why those dates are important is because it shows you the pattern of the defendant's behavior. It allows you to infer his intent on breaking into that house, cutting himself to that degree, and sitting there and lying there and waiting for the victim to come home. Based on his prior actions, the fact when they would get upset, it would be an argument, sometimes it would be physical, and then the defendant would assault her. It is clear that his intent on that date was to at least assault her when he went to the residence and broke in. If not a step further, committed aggravating stalking. Again, those past dates of assault are important because at some point in time, the contact became unconsensual. It became unwilling by the victim. She didn't have to tell the defendant, stop hitting me, I'm going to leave me alone. She left the situation without him, and her actions alone can speak to what her intent was to cut the communication off on those dates. That led up to the 18th when the no contact order, 2 no contact orders, mind you, were in place between the defendant and the victim. But that didn't stop the defendant from breaking into her home. As you'll see with the jury instruction on home invasion second degree, he either entered the home without permission, which I'm claiming he did based on the evidence. He did not have a key. He did not have permission to stay there. He did not live there. Sure, he would spend the night there. He would hang out with his on and off girlfriend, Alexa. but she had to be home and consent to him being in there. If he had permission, why'd he break that back window, ladies and gentlemen? Why? If he had a key, why not use the key? If a door was open on that apartment, it still would have been breaking and entering, but he wouldn't have gone to that extent or have to gone to that extent to get in. The other part of the home invasion is that, or he broke and entered. Ladies and gentlemen, it's clear he broke and entered. Look at the evidence. Look at that window. Look at his injuries. I'm claiming that he did so without permission, or he broke and entered. I'm claiming he did both, but I only have to satisfy one of those requirements. The next step of home invasion is, did he enter the home with any portion of his body? Again, the police found him in the house. Clearly, he had physically entered the home with his entire body. That element satisfied. And as I've been focusing on so far, the last element is that he went there with the intent to commit aggravated stalking and or an assault. He didn't actually have to commit an assault for that element to be proved. He had to intend to commit an assault for that element to be proved. If you, for some reason, don't agree with the charge that he went there to go commit aggravated stalking, look at his pattern of assault when he gets upset with the victim. In some of those prior dates, he went to her house after she broke the contact and assaulted her and entered the home without her permission. Clearly, at the minimum, he went there to commit an assault. As you heard from the officers on scene, there was a lot of blood that was lost by the defendant. Not only that, Sergeant Fleming was on her loud speaker that the whole neighborhood could hear, saying, "Hey, Latrell, get out of the house. The police are here. Please come out. Please come out." And although it wasn't continuous contact by the sergeant's own testimony, it continued for at least 30 minutes. Latrell didn't leave the home. It would have been easier to leave the home at that point in time knowing he's caught than breaking in the manner that he did. Ladies and gentlemen, that is the beginning of the case, October 18th. But there was the consensual contact that started before the 18th. All those prior bad acts at some point became unconsensual contact. As you heard Alexa state, she never asked the defendant to beat her. She never asked the defendant to abuse her. She never asked the defendant to be possessive or controlling, yet he did those nonetheless. Again, you can infer the elements and infer what someone wanted based on actions alone. Ask yourself, if you were being assaulted, if you were being possessed and controlled, if someone was yelling at you, are you going to continue that contact? No. And Alexa even stated she removed herself every time in those 4 occasions and ultimately had police contact. Mr. Crawford stated in his opening that I'm here to confuse you on the issues. I'm here to lead you while you're here. Again, I'm not here to confuse anyone. I'm here to present the case that came in through that stand. The reason why that's important is because look how Alexa testified. She was clearly emotionally distressed by all these interactions with the defendant. She clearly was still affected by the totality of this case to this date, almost a year later. Now, as you heard in Mr. Crawford's opening, Alexa's out for blood. Again, she had the motivation to lie here in court. She had the deception to come in and deceive you. And she manipulated you into potentially believing what she stated. Mr. Crawford's claim was she was a jealous ex-girlfriend that got cheated on. Did she look like that to you, ladies and gentlemen? Did she look like a jealous ex-girlfriend, coming here just to get Latrell in trouble? No. The only reason we're here today are from his actions alone, not hers. You heard her testify that she came into court on 2 other cases against him and asked for those charges to be dismissed. Yet Mr. Crawford wants you to believe that she had the motivation, the deception, and the manipulation to come here and testify in this case today and present you with all those facts of the prior bad acts leading up to October 18th. Clearly, Alexa is not out for blood. She is trying to heal herself from the pain and torment that the defendant caused her. This case, unfortunately, did not stop on October 18th, as you've heard, ladies and gentlemen. The contact continued. I think it's clear as day from all the text messages that were presented and that you can see, plus Alexa's testimony, that she had continual contact even post October 18th, 2020. The defendant sent her numerous amounts of texts, ladies and gentlemen. This stack of texts, just texts, no phone calls, no voicemails, was from February 1st through February 14th of this year, a 14-day period. You can just see how much weight and how thick this stack is. And you'll have the ability, if you would like to, you can go review all of these texts. And you can review all the texts we discussed up until this point. And it is clear that the defendant tried to interfere with her. He didn't want her to come to court. He begged her not to come to court. Please don't come. I'm going to go to prison. I'm going to go in trouble. Talk to the prosecutor. Talk to my attorney. Let him know you don't want to go with the case. Oh, I'm sorry, babe. I'm sorry. Please forgive me. Please forgive me. I want to start a family with you. Leave me alone, the victim would say at times. And other times she would respond to him in a potentially positive manner. But when Latrell wouldn't get his way, he would threaten to kill himself over and over and over. And this cycle repeated continuously from October 18th through February 14th of this year. It is clear that he did not want her to come in and testify. Again, as one of the elements in that count 3, interfering with a witness in a criminal case, the maximum possible penalty of home invasion, the underlying charge, has to be more than 10 years in prison. You heard Detective Warden state that the maximum possible penalty of that is more than 10 years in prison. So that element is satisfied on its face. Again, he didn't have to actually stop her from coming in and testifying. He just had to try to stop her from coming in and testifying, or try to impede, or try to obstruct. Clearly, at the minimum, he attempted to do those things. And it went a step further when she requested 2 of the cases be dismissed. Ladies and gentlemen, as Mr. Crawford stated in his voir dire, how do you judge credibility of a person? By their actions, how they testify, their memory. Alexa admits to drinking on prior occasions where she was assaulted by the defendant, and on the 18th of October. And she had a very good memory about what happened a year ago, or almost a year ago. Is it perfect? No. What did you do 2 weeks ago? Do you know every word that you said to someone, even 2 weeks ago, 3 days ago? Mr. Crawford nitpicked at certain testimony she gave in the preliminary exam and what she gave here in court. Ladies and gentlemen, at best, those are minor differences. And it doesn't change what happened in July, in August, and then in October of last year. Mr. Crawford stated in his opening, there's no corroborating evidence that any of these things happened. It's character assassination on my client, the defendant. Ladies and gentlemen, you heard from Ms. Armstrong on the 14th and 15th in the defendant's actions that she witnessed, a third-party witness who barely knew the defendant. You heard about Officer Atha taking the report at the Township Police Department and documenting the physical injuries that he could observe and what he told her. On August 10th, you heard Officer Baxter testify about what the victim claimed the defendant did in assaulting her by pushing her to the ground, taking her phone. She had injuries consistent with that the officer recognized. A bruised red elbow, I think a red mark on her hand. Then August 30th, you have 3 calls to 911 by the victim. While she was trying to get to safety and go to the township police department, the defendant followed her, and he tried to ram her off the road on multiple occasions. Luckily, she was able to get home and get away from him for a brief period of time. But you could hear, I hope you could hear, at 4:30 in the morning on the 30th of August of last year, she's taking deep breaths. Ms. Van Warmer is a soft-spoken person. You heard her testify for 2 hours. I think you can gather that for yourself. She was soft-spoken on the phone, but that doesn't minimize the fear and terror she had from the defendant. She told Officer Deal that she thought the defendant was going to kill her when Officer Deal interviewed her. And again, guess what, ladies and gentlemen? The defendant was at her residence on August 30th when the police arrived, and he was in that same tan Buick rendezvous she said he followed her in. Corroboration, corroboration, corroboration. You saw pictures of injuries that she sustained. You saw a bruise over her lip that the defendant committed when he assaulted her by punching her in the face. That was documented on August 30th of last year. Who was out for blood here? Not Alexa. Ladies and gentlemen, I'm going to show you a couple pictures that you'll be able to see back when you're deliberating on this case, and that you've seen throughout the course of this trial. This is the window that the defendant broke with blood around it from the outside. Would a reasonable person do that to get in a home? This is an interior photo of that same window over the sink. Would a reasonable person inflict that amount of injury to themselves just to try to retrieve some property that the victim might have had? Again, you walked all over the house looking for the victim on that night or early morning hours of October 18th. You saw the blood spread throughout the home. Does this look like the actions of a man who only intended to enter the home to get his cell phone and keys? Again, why did he go there on October 18th? It's clear, ladies and gentlemen, based on his pattern of abuse and violence towards the victim. I'm not going to go through all the elements of each of the charged offenses in this case. Count 1, home invasion, second degree. Count 2, aggravated stalking. And count 3, interfering with a witness on a criminal case. The judge will do that. And I covered those in my opening. All I ask is that you use your common sense. And again, only apply what came in through that stand. The evidence, the exhibits, the testimony. I'm just giving you a summary about what I believe. But when you use your common sense, you will realize that each one of those elements I have to prove beyond a reasonable doubt for all 3 counts have been proven. Additionally, even if you have some concerns about other things with this case or the relationships and more questions about the relationship between the defendant and the victim, those aren't elements that I have to prove, ladies and gentlemen. They aren't. I don't have to prove motive, even though I think I showed you a motive. I don't have to show a film or photographs of the defendant actually assaulting her or actually breaking into the home. We've talked about this at length. And ladies and gentlemen, when you use your common sense, you will learn and understand that the only person that had the motivation to commit these crimes, the only person that had the deception to commit these crimes, and the only person to be manipulative throughout the course of this case is the defendant, Latrell King Jr. Thank you.
Closing remarks, Mr. Crawford.
Good morning. Yesterday, we heard a lot. Heard a whole lot about July the 10th or July 14th, July 15th, August 30th, August the 10th, I think. A lot about domestic violence. A lot about cases that you're not here to reach a decision on. A lot about cases that have already been adjudicated. But that was the prosecution's plan from the get-go. They wanted to make this case about something that it isn't. Domestic violence is not a charge here. Realistically speaking, we look at the evidence that came in. This case should have been over yesterday at noon. We only heard from 4 witnesses that knew anything about October the 18th. Officer Charles Gibson, Sergeant Fleming, Alexa Van Warmer, and Detective Warden. Everyone else, a waste of time, completely irrelevant. It's useless. Let's bring in the roommate. Let's bring in the officer from July 15th. Let's talk about the officer from August 30th, the 911 guy. It doesn't matter. Latrell King is not on trial for any of those cases. They're not here to prove the elements of domestic violence. And that's why I sat in my chair the entire yesterday afternoon and didn't question one witness except for Detective Warden. He's not beyond charge. And then I also told you he's already guilty of interfering with the witness. So that only leaves us with 2 charges that we really need to focus on here. Home invasion in the 2nd degree, aggravated stalking. Everything else, it doesn't matter. A waste of time, a waste of resources. Now, we heard from Alexa Van Warmer, and they constantly referred to her as the victim. But truthfully, is there really a victim here for the charges that you're supposed to decide on? Forget the domestic violence, okay? We're not here for that. Ask yourself, on October the 18th, was she being stalked? Did Latrell do something to her on October the 18th that I missed? He didn't force her to drive him to Detroit. He didn't force her to make these reservations at this Black Rock restaurant. No, didn't do anything against her own will. Furthermore, we heard testimony from her in which she stated at the preliminary examination, there were no acts of violence. There was nothing, there were no threats directed towards me. I was not in fear on this day. But now the prosecution, they want to make a leap and say that Latrell had a specific intent to commit aggravated stalking or an assault. He's in the house, on the couch, sleep when the investigators come in and arrest him. Nothing that they've presented demonstrates anything on October the 18th that shows Latrell had a specific intent to commit aggravated stalking or an assault. That's their burden. That's what they had to prove to you beyond a reasonable doubt. All they can claim is that he didn't have permission to be in the house on October the 18th. Okay, but that doesn't satisfy all the elements of home invasion in the 2nd degree, not even close. And now they said that I'm nitpicking at Alexa's testimony? No, absolutely not. Let's break down some of what she said and some of the lies that she talked about on direct examination. You all remember her, and the prosecution continues to say, she talks about, oh, Latrell wouldn't let me put on makeup. Latrell wouldn't let me go on Facebook. Latrell wouldn't let me post pictures. And then when we actually go through her text messages, what does she say? On November the 11th, I definitely am beautiful, but you knew that. Everybody does. I post pics 24/7 without makeup. I'm confused why you so butthurt. Oh, I hurt your feelings that bad? I definitely look better than every bitch you had, and I got more than them. I am a queen. I'll see you Thursday, and you're going to be sick because I was going to stick up for your little ass, but F you. That's her own words. That's what she texted him. What else did she say? While she was here at the trial on direct examination, she's talking about, oh, I remember talking to an officer while I was at the jail and I told them X, Y, and Z. Really? When you testified at the preliminary examination, you said that you didn't remember talking to any officers while you're at the jail. And then this whole story about her, oh, I never had his phone. I never had it, not one time. Really, Alexa? If you didn't have his phone, then why are you texting him, asking him for the passcode to his phone and cussing him out because he won't give it to you? Does that make any sense? Or you just want the passcode just to have it? Or do you want the passcode so you can get in there and see if he's cheating? Use your common sense. And that's a common trend that's going on throughout this case with Alexa Van Warmer. She's a liar. The 911 call, where she's so calmly talking about Latrell trying to run her off the road, what did she say in there? Oh, my kids. She constantly talks about my kids, my newborn. Detective Warden, the first question. Does Alexa have any kids? No. So she lied, right? Yes. Alexa is a liar. If you lie about the small things, you'll lie about the big things. If it doesn't fit within her story, then she wants to distance herself from it and deny it. But no matter how bad she tried to fight me on certain topics, she can't deny her text messages she sent. She can't deny the preliminary examination transcript. And she can't deny her own actions from October the 18th through February the 14th. Motivation, deception, manipulation. And when Alexa was on the stand and we were talking about what she had to drink, she was very specific about what she said she had to drink. She didn't say that she had a glass of Hennessy. No. She didn't have a wine cooler, not a beer. She told us that she drank a fifth of Hennessy with Latrell King. And just so you all can understand what I'm talking about here, a fifth of Hennessy, hard liquor, cognac, an entire bottle at dinner, and then drove 2 hours drunk from Detroit to Saginaw. We heard from Sergeant Fleming when she talked to her at the jail, she said that she was belligerent. Now, you use your common sense. You've seen the text messages that she sent when she's allegedly sober. What do you think she's like when she's got a fifth of liquor in her system? Some of the most telling messages that I saw when going through the thousands of messages between her and Latrell come on October the 30th, 12 days after the incident. Now it's my turn to shit on you and her. F both of y'all. Motivation, deception, manipulation. She's clearly not just upset with Latrell. She's angry with him. And not about her window being broke or blood being on her carpet. She's angry and she's upset because of him cheating. Now it's my turn to shit on you. She left him at the gas station. She told him that she told us on the stand that when she left, she said nothing to him. Pulled off at a high rate of speed with his cell phone and his keys in the car at 4 o'clock in the morning. Not one word. She didn't leave his phone there at the gas station for him. She didn't send him a text. He has no way of communicating with her, no way of communicating with anyone. He's out there in the dark by himself without any form of communication. Communication is the key to clarification. And they're clearly, without question, in a relationship. Nothing is stalkerish about October the 18th. The prosecution is continuously saying she didn't want to be bothered by Latrell. But she's doing all of this stuff to keep Latrell in her life. She knowingly and intentionally disregarded the no contact order. Text messages, video visits, phone calls. 4 months after the alleged incident, they want you to believe she's afraid of him, but she's on surveillance footage going into his house on February the 1st at 12:30 in the morning. Thousands of text messages between them. She could have easily blocked him. No, she's texting him. They're going back and forth. Unconsented contact? Please. I told you in my opening, this is not a relationship that any parent would approve of. This is not a relationship that's healthy. But at the end of the day, this was their relationship. And then they want to claim this is unconsented contact when she's reaching out to him and she's going out of her way to spend time with him. From October the 18th to February the 14th, there's no question that she loved him and she wanted to have children by him, as evidenced by her own text messages. Now, there was also important testimony that came in from the final witness, Detective Warden. And she talked about this continuous, nonstop cycle between Latrell and Alexa. I love you. I hate you. You're cheating. I miss you. I love you. Nonstop. But what's most important is she talked about the investigation. She told us that Latrell was charged on October the 20th, 2 days after the incident. They had to fit this within that 72-hour time frame, okay? But prior to issuing charges, there was no real interview conducted with Alexa. Prior to issuing charges, the prosecution and the police did not know that Alexa drove Latrell to Detroit. Prior to issuing charges, they didn't know that they had a scheduled dinner in Detroit. Prior to issuing charges, they certainly didn't know that Alexa had drank a fifth of Hennessy. Prior to issuing those charges, they also didn't know that Alexa left Latrell at the gas station, left him there, and didn't give him his cell phone or the keys to his house. They issued charges without knowing anything about this situation other than there was a no contact order and Latrell King was found inside of the house. That's a rush to judgment. There's no other way to look at this. This is why they had to spend so much time on July 15th, August 12th, or whatever those days were, because they're trying to shore up the deficiencies in their own case. When you look at the actual evidence, the evidence about October the 18th, it's clear that this case is mischarged and it's overcharged. They charged Latrell without knowing the full set of facts. They knew 1/5 of the story, didn't even interview Alexa Van Warmer. That's a rush to judgment. Reasonable doubt can arise from the lack of evidence, the unsatisfactory nature of the evidence, and the evidence itself. The prosecution didn't come close to meeting their burden on the other charges because the evidence simply isn't there. Now, I want to take some time to go through some very important jury instructions that Judge Jackson is going to go over with you all later. Shortly, I have to say. Home invasion, second degree. The main thing that we want to focus on here, of course, a lot of these elements, they talk about a dwelling being broken into. Latrell is found in the house. He's sitting on the couch when they come there. Okay, we got that. He got his whole body inside of the house. Fine, all right. But the last element, the most important element, the element the prosecution, oops, turn it, sorry. When the defendant broke and entered the dwelling, he entered without permission and that he intended to commit aggravated stalking or an assault. How can you make that leap? How can you say that he had a specific intent when he's left at the gas station with no phone, no keys? She didn't tell him, hey, I'm just leaving you here. You're on your own. I don't want to see you. No. When she left him there, he knew that she was drunk. When she left him there, the plan was to go back to her house. And after a fifth of Hennessy, she left. Are we really going to, and there's no acts of violence between the two on October the 18th? How can they logically make the jump and say, oh, he's going in there to hit her? He's going in there to stalk her. They went on a date, not going in there to do anything. When the officers came in the house, he's sitting on the couch, asleep. He's not running through there in a frantic pace. He's not tearing the place up. He's on the couch. There's also going to be an instruction about entering without an owner's permission. When I say the case is mischarged and it's overcharged, Read through this closely. Read through it very closely. Ask yourself, does this fit or is it home invasion in the second degree? What lines up better with the facts? Aggravated stalking. The most important thing that I want to focus on here is going to be in number 2, unconsented contact. October the 18th, and the prosecution has to prove to you beyond a reasonable doubt that Latrell King committed 2 or more willful, separate, and non-continuous acts of unconsented contact with Alexis Van Warmer. October the 18th, was it unconsented when she drove to his house and picked him up? Was it unconsented when they sat there and had a romantic dinner and drank a fifth of Hennessy? You tell me. Unconsented? Absolutely not. It's a burden that they're not going to be able to meet, and they haven't met. I already told you that he's guilty of interference with the witness. No point in wasting any time and resources on that. But this is the important thing, and I want you all to focus on this. Time and place. I've told you from the beginning, the prosecution has been trying to mislead you and confuse you. They keep talking about July 15th, the no contact order. No, the judge is going to read this to you verbatim as to count 1 and to count 2. Now we're talking about specifically home invasion in the second degree, aggravated stalking. The prosecutor must prove beyond a reasonable doubt that the crime occurred on or about October the 18th, 2020. Okay? So all of this aggravated stalking stuff, talking about July, talking about August, no. October the 18th. This is the venue. So if we're focused on October the 18th, how can they say that this is unconsented contact? They can't. That's why they're talking about all this other stuff. That's why they're trying to confuse you. That's why they're trying to mislead you. Now, this is my final time speaking to you. Prosecution, as they already told you, they're going to have an opportunity to come up and give a rebuttal argument. But I can't reiterate this enough to you. This is not complex. This is not rocket science. This is October the 18th. Couple of issues you got to consider. Straightforward. Latrell King is not charged with domestic violence. The prosecution focused 80% of their time focusing on domestic violence, and they neglected to address the real issues. They neglected to address the issue of unconsented contact. They neglected to address the issue of a specific intent when he entered the home. Use your common sense and do not allow yourself to be misled on the real issues. Do not become misled on why you're here. All of that domestic violence stuff doesn't matter. Of course, it's serious, but as it pertains to October 18th and why you're here, it doesn't matter. Reasonable doubt. The same reasonable doubt that we talked about during voir dire, jury selection. Same reasonable doubt that you want applied as if it's your brother or your sister sitting at this table. Reasonable doubt can arise from the lack of evidence, the unsatisfactory nature of the evidence, or the evidence itself. I ask that you find Latrell King not guilty of home invasion in the second degree and aggravated stalking. Thank you.
Rebuttal remarks, Mr. Sutter.
Ladies and gentlemen, even what Mr. Crawford just said, because Alexa drank Hennessy that night, it doesn't make her victim. Nope. Because Alexa had contact after the fact with the defendant, it doesn't make her a victim to this crime. Nope. Can't. Mr. Crawford is doing his best to shift the blame in this case to the victim. She was forthcoming. And when she was informed about things that were stated different between the preliminary exam and her testimony at this trial, she had no reason to disagree with what was in the transcript or with what Mr. Crawford was suggesting. She wasn't combative with Mr. Crawford during his cross. She didn't argue with him. If anything, he cut her off many times before she could fully answer a question. Why? Again, how is this a character assassination of the defendant when it's his actions alone that bring us here today? Mr. Crawford also would like to believe that the 18th and the contact, or the fact that the defendant went to her home and broke in the nature that he did, that's not unconsensual contact. You heard from Sergeant Fleming that the victim was hysterical when she found out the defendant broke into her home. She clearly was disturbed and troubled, terrorized, threatened by his actions on that night, even though she was never there when he did this. Luckily, she was within the safety of the Saginaw County Jail when he broke into her home. Again, Mr. Crawford focused on the fact that police didn't interview Alexa before charges were issued. Ladies and gentlemen, at this point, that doesn't matter. You've heard the entirety of the relationship, at least between July and October and a little bit past that. So you did get to hear the fact. Alexa admitted that they went to dinner. It was consensual at that point. But the consent can stop on a dime, and it can stop on actions alone. Why the prior acts of domestic violence are so important is generally, ladies and gentlemen, you do not get to hear about prior acts in a criminal case. You generally have to judge an individual on the date of offense itself. But the law allows you to hear about those other acts. And it allows you to consider, did Latrell break into that house and bloody himself to kingdom come to then commit an assault or to then commit aggravated stalking? Why? Why would Latrell have gone to that extent to get in that home on that day? It is clear that he went there with those intent, or with that intent. He could have just walked home, 3-minute walk, and tried to get his phone and keys the next day or within some time frame. He made the choice to walk to her house, a 25-minute walk. The victim didn't choose that for him. She didn't know she had his keys and phone in the vehicle. She was more concerned about getting to safety. Yet again, somehow, based on Mr. Crawford's theory, this case and all these prior assaults and bad acts are the victim's fault. They're the victim's fault because she did continue communication and contact with the victim or with the defendant after he would assault her. It's her fault because she would go interact with him. That's ridiculous, ladies and gentlemen. This case has been on a straight path the entire time, a clear road. I have not misled or confused. I'm pretty sure most of the stuff I talked about in my opening was shown, if not everything, during this course of this trial. But again, it doesn't matter what I say in my opening and closing. It doesn't matter what Mr. Crawford so passionately says in his opening and closing. It only matters what comes in as evidence from that stand. You can have consensual contact and it can stop on a dime, like I said. You can go and look at the text messages that are introduced as exhibits while you're back deliberating in the jury room. And you'll see from the get-go, October 24th, leave me alone, Alexa told the defendant. I'm done with you, she told the defendant. Leave me alone. Did he leave her alone? After she told him to leave her alone, he had contact with her. You'll see a jury instruction for contact. Contact is not just face-to-face contact. Over the phone, telecommunications, it's in person, going to someone's residence, regardless of if they're there. You'll see that in the jury instruction. It's not just face-to-face contact. And again, it's the cycle. Yes, she tries to forgive him at times after the 18th and before the 18th. There's no denying that. She did not deny that. She didn't shy away from that. But the way that Mr. Crawford wants this case to come out is she came in here and lied to you about everything. She lied to you about the 14th and 15th of July of last year. She lied to you about August 10th of last year. She lied to you about August 30th of last year. And then lied to you about October 18th of last year. And then, doesn't stop there, lied to you all the way up to February 14th in that communication with the defendant. Is that what the evidence showed, ladies and gentlemen? Is that what the evidence showed? You know, I'll end on this, ladies and gentlemen. The defense, as you've heard in his opening and his closing, he stated that his client is guilty of count 3, interfering a witness on a criminal case. If there's no merit to home invasion of the second degree, and if there's no merit to aggravated stalking in count 2, or they're overcharged, why would he conclude and tell you his client's guilty of interfering with the witness on those related charges? If there was no merit, how did any interference happen in the first place? I don't know, ladies and gentlemen. Again, at the end of the day, use your common sense. That's all I ask. Use your common sense, use what you've been given through this trial, and apply that to the elements of each of the crimes. And once you do, you'll realize that Alexa was not out for blood. She had nothing to gain other than trying to heal by coming in and testifying, and that the defendant is guilty as charged. Thank you.
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember, you've taken an oath to return a true and just verdict based on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that you may have unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, I doubt that is reasonable after a carefully considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyer said that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider these things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge you may have about a person, place, or event. To repeat once more, you must decide the case based on the evidence admitted during this trial. As I said before, it is your job to decide what the facts for this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. A, was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? B, did the witness seem to have a good memory? C, how did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? D, does the witness's age and maturity affect how you judge his or her testimony? E, does the witness have any bias, prejudice, or personal interest in how this case is decided? F, have there been any promises, threats, suggestions, or other influences that affected how the witness testified? G, in general, does the witness have any special reason to tell the truth or any special reason to lie? H, all in all, how reasonable does a witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree. You must decide which testimony you accept. You should think about whether the disagreement involves something important or not, whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that the witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecution has presented evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, You may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat, covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You've heard evidence that before the trial, a witness or witnesses made a statement or statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. You may consider whether the defendant had a reason to commit the alleged crimes, but a reason by itself is not enough to find a person guilty of a crime. The prosecutors do not have to prove that the defendant had a reason to commit the alleged crimes. He only has to show that the defendant actually committed the crime and that he meant to do so. The prosecution has introduced evidence of claimed acts of domestic violence by the defendant for which he is not on trial. Before you may consider such alleged acts as evidence against the defendant, you must first find that the defendant actually committed such acts. If you find that the defendant did commit those acts, you may consider them in deciding if the defendant committed the offenses for which he is now on trial. You must not convict the defendant here solely because you think he is guilty of other bad conduct. The evidence must convince you beyond a reasonable doubt that the defendant committed the alleged crimes, or you must find him not guilty. The defendant's intent may be proved by what he said, what he did, how he did it, or any other facts and circumstances and evidence. You've heard that a lawyer or a lawyer's representative talked to one of the witnesses. There's nothing wrong with this. A lawyer or a lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. In count one, the defendant is charged with home invasion in the second degree. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant broke into a dwelling or that the defendant entered a dwelling without permission. To establish a breaking, it does not matter whether anything was actually broken. However, some force must have been used. Opening a door, raising a window, and taking off a screen are all examples of enough force to count as a breaking. Second, that the defendant entered the dwelling. It does not matter whether the defendant got his entire body inside. If the defendant put any part of his body into the dwelling, that is enough to count as an entry. Third, that when the defendant broke and entered the dwelling, or entered the dwelling without permission, that he intended to commit aggravated stalking and or an assault. An assault is defined as follows. First, that the defendant either attempted to commit a battery on another person, or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. Second, that the defendant intended to either commit a battery upon someone or to make someone reasonably fear an immediate battery. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought he had the ability. Aggravated stalking is defined in a later instruction. Under count one, you may also consider the lesser charge of entering a building without the owner's permission. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant entered a building. It does not matter whether the defendant got his entire body inside. If the defendant put any part of his body into the building, that is enough to count as an entry. Second, that the defendant did this without first getting permission to enter from someone who had authority to give permission. In count two, the defendant is charged with aggravated stalking. To establish this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed two or more willful, separate, and non-continuous acts of unconsented contact with Alexa Van Wormer. Second, that the contact will cause a reasonable individual to suffer emotional distress. Third, that the contact caused Alexa Van Wormer to suffer emotional distress. Fourth, that the contact would cause a reasonable individual to feel terrorized, frightened, intimidated, threatened, harassed, or molested. Fifth, that the contact caused Alexa Van Wormer to feel terrorized, frightened, intimidated, threatened, harassed, or molested. Sixth, that the stalking was committed in violation of a court order. Unconsented contact means any contact with another individual that is initiated or continued without that individual's consent or in disregard of that individual's expressed desire that the contact be avoided or discontinued. Unconsented contact includes, but is not limited to, any of the following: following or appearing within the sight of that individual, approaching or confronting that individual in a public place or on private property, appearing at that individual's workplace or residence, entering onto or remaining on property owned, leased, or occupied by that individual, contact that individual by telephone, sending mail or electronic communications to that individual, placing an object on or delivering an object to property owned, leased, or occupied by that individual. Emotional distress means significant mental suffering or distress that may, but does not necessarily, require medical or other professional treatment or counseling. In count 3, the defendant is charged with the crime of witness interference. To prove this charge, a prosecutor must prove each of the following elements beyond reasonable doubt. First, the Alexa Van Wormer was an individual who was testifying or going to testify or going to provide information in an ongoing or future official proceeding. An official proceeding is a proceeding heard by a legislative, judicial, administrative, or other governmental agency or official authorized to hear evidence under oath. Second, that the defendant impeded, interfered with, prevented, or obstructed Alexa Van Wormer from attending, testifying, or providing information, or tried to impede, interfere with, prevent, or obstruct Alexa Van Wormer. It does not matter whether the official proceeding took place, as long as the defendant knew or had reason to know that Alexa Van Wormer could be a witness at the proceeding. Third, that the defendant intended to impede, interfere with, prevent, or obstruct Alexa Van Wormer from attending, testifying at, or providing information at the official proceeding. Fourth, that the official proceeding was a criminal case, charging a crime with a maximum punishment of more than 10 years or life. As to count 1 and count 2, the prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about October 18th, 2020 within Saginaw County. As to count 3, the prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about October 18th, 2020 to February 14th, 2021 within Saginaw County. When you go to the jury room, you will be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way, and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, we discuss the case among yourselves, but ultimately, each of you have to make up your own mind. Any verdict must represent the individual, considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them. Keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you are wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. I've already given you instructions regarding a lesser offense. As to any count which includes a lesser offense, you must first consider the principal offense. If you all agree that the defendant is guilty of that offense, you need not consider the lesser offense. If you believe that the defendant is not guilty of the principal offense, or if you cannot agree on that offense, you may consider the lesser offense. It's up to you to decide how long to consider the principal offense before discussing the lesser offense. You may go back to consider the principal offense again after discussing the lesser offense if you want to. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to my law clerk. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my law clerk. It's not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in this case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the exhibits that have been admitted, just ask for them. When you go to the jury room, you'll be given a written copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. So the defendant is charged with 3 counts. These are separate crimes, and the prosecutor is charging that the defendant committed all of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all or any combination of these crimes, guilty of a less serious crime, or not guilty. I've also prepared a verdict form listing the possible verdicts for you. It reads as follows. Count 1, home invasion, second degree. Your possible verdicts are not guilty, guilty of home invasion, second degree, guilty of the lesser offense of entering a building without owner's permission. Once you reach a verdict on this count, your foreperson will sign and date the verdict form. Count 2 says aggravated stalking. Your possible verdicts are not guilty, guilty of aggravated stalking. Once again, once you reach a verdict, your foreperson will sign and date the verdict form. Count 3 says interfering with a witness. Your possible verdicts are not guilty, guilty of interfering with a witness. And once again, once you reach a verdict on this count, your foreperson will sign and date the verdict form. I'd like to see counsel at the bench for a moment, please. I'll also ask you all to stand and take the oath of deliberation. Please stand.
You and each of you do solemnly swear that you will well and truly try the issues joined in the cause now here pending, and unless discharged by the court, a true verdict render, and that you will do so solely on the evidence introduced and in accordance with the instructions of the court. So help you God.
Okay, we now administer the oath to the law clerk, please.
Do you solemnly swear that you will, to the utmost of your ability, keep the person sworn as yours in this trial in some private and convenient place, that you will not suffer any communication to be made to them orally or otherwise, that you will not communicate with them yourself orally or otherwise, except by order of the court, or to ask them if they have agreed upon their verdict until they shall be discharged. That you will not, before they render their verdict, communicate to anyone the state of their deliberations or the verdict they have agreed upon, so help you God.
All right, ladies and gentlemen, at this time, we may go with my law clerk to begin your deliberations. Please be seated. Record should reflect the jury is not present at this time, and after the court had instructed the jury, had counsel approach the bench for any additions, deletions, objections, or corrections. Mr. Sauter, I believe you had none.
None, Judge.
Mr. Crawford, I believe you had none.
That's correct, Your Honor.
All right, anything else for the record, Mr. Sauter?
No, Your Honor.
Mr. Crawford?
No, Your Honor.
Okay, if you intend to leave the building, I would request that you give my staff contact information in case the jury has further questions or reached a verdict. You're free to stay if you want to do that also. We'll stand in recess at this time.